Greetings and welcome to Chapter 4 Civil Liberties. Before we dive into the content, I have a quick story. I have a total of 3 brothers, and 2 of my younger brothers and we went to visit a friend in Massachusetts. Now, I need to remind you real quick. This happened years after the terrorist attacks on September 11th. So here we are. We're flying back home. We're coming back home. We're in mid-flight, and one of my younger brothers asked the other brother and I, "Do you think I'll get in trouble if I say the word bomb?" Something about me, real quick. I am not embarrassed easy, like at all. My second day of teaching, I fell in front of a full packed classroom of about 32 students. I have unfortunately fallen down the stairs at a packed restaurant at peak time during lunchtime. Um, it doesn't affect me. I'm not embarrassed easily. But this day, on this flight, coming home, I in fact was. Now, you may be wondering, what happened? Was the air marshals involved? Did we get detained? Were we asked any questions? And I had already made up my mind in my head that if that I would deny I even know this guy, despite looking like him. Fortunately for me and him and my other brother, no, nothing happened. Nothing at all happened. But I like to share that story to kick off civil liberties, because we're going to be coming back to this theme of freedom, of what freedoms we have, right? The freedom of speech that we have. Do we have absolute free speech? And that's going to be a question we're going to be looking at as we progress through this lecture. And I want you to think about that. Do I have free speech? Absolute free speech. So, with that context set up, let's dive into civil liberties. So, let's start off with a definition, right? So, let's start off with what are civil liberties. Civil liberties are limitations on the power of government designed to ensure personal freedoms. Now, it's been my observation that we sometimes we often link civil liberties to civil rights, or we somehow use them interchangeably. That's not the case. Civil liberties are not civil rights. They are completely different. They are not the same thing here. So we will discuss civil rights in the next video, so don't worry, we will cover that. But for right now, just note that civil liberties are limitations on the power of government. Civil rights are equal protections from discrimination under the law. 2 completely different concepts here, right? They are not the same. So, with that out of the way, let's dive now deeper into these limitations on the power of the government. So, let's kick this off with due process clause. The due process clause are provisions of the 5th and 14th Amendments that limit government's power to deny people life, liberty, or property on an unfair basis. Okay, so with due process, right, the police can't just bust down your door and arrest you without probable cause, without reason, without a warrant, without just legal justification. Okay, they can't just do that. We have to be detained. Okay, your due process rights must be upheld. They must be respected. Okay, so this is a limitation on the government, that they can't just seize you. They can't just detain you for whatever reason they find, for whatever reason, whatever cause they come up with, they have to have legal, just justification for this. So these due process rights protect you and I from that. Okay, from just randomly being interrogated or randomly being incarcerated for whatever reason, some random reason. Okay, it has to be, our due process rights have to be respected. Okay, and that comes from the 5th and 14th Amendments. The selective incorporation process. This is a gradual process, making some guarantees of the Bill of Rights, so far, apply to state governments and the national government. So there is an argument that the Bill of Rights only applies to the federal government. It doesn't apply to the states. That's the argument. And this selective cooperation process, while it is slow, it's rectifying that. Well, no, the Bill of Rights does in fact apply to the states, and the Supreme Court is going through this in selective cooperation process. So that's what we need to note here. Other limitations on the restrictions, other limitations on government, right? These limitations on government. We need to go to Article 1, Section 9 of the U.S. Constitution. The Bill of Attainder, that is a law that convicts or punishes someone for a crime without a trial. This is strictly forbidden by the Constitution. The U.S. Constitution clearly makes this a no-no. This is a complete, this idea of a Bill of Attainder completely violates the Due Process Clause of the 5th and 14th Amendment. So the Bill of Attainder is strictly forbidden. This is not a practice. This is a practice that the Constitution protects government from, if that makes sense. Okay. Ex post facto law, that is a law used to punish crimes that were not crimes at the time they were committed, or it can be used to increase the severity of punishment after the fact. This, in fact, is again forbidden by the U.S. Constitution. It is strictly forbidden. We cannot be tried for a crime that was not a crime for when we did that. The U.S. Constitution protects us from this. Okay, so we see these limitations on what government can do. Now, you and I may think this is almost like a no-brainer, right? That this would be our expectation. We have to realize other systems of government, that's not the case, right? When we have authoritarianism, when we have totalitarianism, citizens really don't have rights. So this is a cornerstone. The fact in the U.S. Constitution, the fact that there is limitations, that there is somehow accountability on government in terms of its relationship with you and I, right? The right of habeas corpus. This is a court order requiring a public official to bring an individual held in custody to court with a reason they are being held. We have the right to know that we are being held and why we are being detained, why we are being held. We have this right. This right is protected by the Constitution. Now, when we talk about civil liberties, just real quick, I want to get this out of the way real fast. When we talk about civil liberties, you possess freedoms simply because you exist. You have freedoms simply because you are human and you are alive. Full stop. Okay? So anyone, and the Supreme Court has been pretty clear about this throughout U.S. history, that to have these protections from government, these limitations on government, you only have to be a human being. Right? It does not matter what nationality you belong to. It does not matter your religion, your religious affiliation, your party affiliation. None of that matters. The Supreme Court has been clear that personhood is what is why you have freedoms. Okay, so it doesn't matter if you are a resident of the United States, if you live within the borders of the United States. Okay, you are protected by the U.S. Constitution because you are a human being. That's it. Okay, so I just want I want to make sure I got that in here, right? So moving on now with a struggle that we are in fact facing, and that is this balancing act between security and liberty. This discussion is not for the faint of heart, because this is a difficult task. This is a difficult conversation, especially when we apply this to situations such as gun violence. How do we balance security and liberty? This idea of safety and freedom. How do we balance the two? And this is a difficult balancing act. This is not for the faint of heart. So, Benjamin Franklin is quoted for saying, "Those who would give up essential liberty to purchase a little temporary safety deserve neither liberty nor safety." So what is he saying here? Well, in other words, what he's trying to get at here is, if a society is willing to give up liberty, if it's willing to give up freedoms, then it deserves neither security or freedom. It deserves neither of these. That's what he's getting at here. And this assertion that he makes, I have to ask you, do you agree with him? Right? This idea of balancing, and if you're willing to give up just a little freedom to secure safety, then you deserve neither of these things. Do you agree with him? Because this is going to be an interesting topic. This is going to be an interesting concept to recall when we get to the Second Amendment. How do we, and by the way, I do not have an answer to this. I don't. How do we balance liberty and security? This is a very difficult conversation. I don't know the answer to this. I'm just being honest with you. I don't. But we will get to deeper part of this here in a moment. But this struggle really became predominant within U.S. society when we got to 2001. Okay, so before we talk about the Patriot Act, I want to take a moment real quick to give you guys some background. You may recall what life was like prior to September 11, 2001. But in case you don't, I do. I was about, if I'm doing my math correctly, just real quick, I was about 19, 20 years old in 2001. And the reason why I hesitate is because when my birthday is. it's in September. Anyways, the idea here, though, is that I remember what life was like, okay? And things changed. Oh, my goodness. Like, for example, when my dad used to travel overseas, my dad traveled overseas when I was a young kid. And I remember as a child, as a kid, as a teenager, going with my dad to the airport, into the terminal, and literally watching him board the plane and watching his particular plane take off. I saw this. Security really wasn't a thing. If it was, like, we only walked through a metal detector and that was it. There was like no one there. It was very laid back. Anyone who has flown today knows this is not the case, right? Politically speaking, now 2000 we had a little bit of a rough election. That was my actually first election to vote in. And I remember it was a little rough because of what happened in Florida, right? How votes were being tallied, and how when they were being tallied, the vote count changed, and the media rushed to call a winner. And you know, Al Gore, he did call President Bush to concede, and then he took that concession back. It was a bit of a mess. And of course, the U.S. Supreme Court kicked in and ruled in favor of George W. Bush. Why am I telling you that? Because when September 11th happened, politics ended for about a week. Okay, no, that's politics ended for a couple of years. Okay, what I mean by that is Republicans, Democrats, this didn't matter anymore. It was all about America. We Democrats, Republicans, we saw each other. We saw the pain that we all suffered. We saw what New York went through, what Pennsylvania went through, and we said, what can we do? There was no Democrats who supported Republicans, and we saw this support, and we saw unity, serious unity across the land. Again, why am I telling you this? Because politically speaking, we had a rough. President Bush had a rough start, but then September 11th happened, and we all rallied around him. We'll talk about rally around the flag effect. It's basically when everyone, when the opposition party, and when Americans rally around the president. We'll talk more about that in future videos. But for right now, just note that we rallied, and politically we were transformed. 9/11 transformed us. Now, of course, we saw some negative side effects, right? We saw blaming Muslims for terrorism. We blamed them for things that they did not do, right? We should always blame the people who were the perpetrators, not those who may look like, or who may sound like, or who may have something in common. Because after all, you and I, every one of us have something in common. We all are human, okay? So guilt by association definitely is not we unfortunately dive into that. We embrace that out of fear. I'm not justifying it whatsoever, because it was absolutely horrible. We should never judge someone like that, ever. But I'm digressing a little bit. Point I'm trying to get at, September 11th changed a whole lot. And one last political thing I want to mention. Prior to September 11th, 2001, American thought was, we have a neighbor to our north, Canada. We have a neighbor and a friend to our south, Mexico. We have a huge body of ocean to our east and a huge body of ocean to our west. We're sitting pretty. We actually thought we were invincible, to be frank. Because the last attack on our soil was World War II during Pearl Harbor. So we never thought for a moment that we were vulnerable. September 11th changed that. So we saw changes, is what I'm getting at. Saw some significant changes. We lost we lost over 3,000 lives that day. And I will forever remember where I was, what I was doing, what was going on that day for me. I will forever remember that on that day. So it changed. We changed. And with that change came the 2001 Patriot Act. Again, remember, we're talking about this balance between safety and liberty. Now we're diving into this. But the Patriot Act was a law passed by Congress in the wake of 9/11 terrorist attacks that broadened federal powers to monitor electronic communications. The full name is the U.S. Patriot Act, which means the acronym stands for, if I can read, uniting and strengthening America by providing appropriate tools required to intercept and to obstruct terrorism act. The U.S. Patriot Act. Okay, so unfortunately, Congress passed this, President signed it into law as a way to act. We were attacked. What can we do? What measures can we adopt that can prevent something like this from happening again? And so the Patriot Act was passed as a mechanism to address that. Okay. Unfortunately, the Patriot Act was also renewed multiple times, not only under President Bush, who was a Republican, but also under President Obama, who was a Democrat. So the Patriot Act was continuously renewed. And we know now from reporting that the NSA was seizing Verizon phone records, not only of those that the government was suspicious of, not only of those who might have been terrorists or terrorists themselves. No, they were seizing phone records of every average everyday citizens. So this is a problem, right? There is a CNN news link I will have available for you so you can click on and watch it. This breaks it down more on what this story is and how the government was doing this. So I'll make sure that's available to you. But for right now, just note that, Patriot Act was used as a way to help prevent, but it was used in a manner that violated civil liberties. So what are your thoughts about that? What are your thoughts about balancing security and liberty? This is not easy, right? Because while one may want to say, I'm all for freedom, well, that's great, but how do you balance that with security? You may think, I'm all about security. I want to make sure that, what good is free speech if I don't have security? I can't practice free speech if I'm not safe. You may be thinking that. But how do you balance these two thoughts? Right? This is difficult. This is not easy. But we must ponder it, and we must think about an answer to that. So, civil liberties, that is. Let's talk about the First Amendment. Right? The First Amendment contains 5 liberties that are protected from government intrusion. 5. Within this one amendment, we have 5 protections. Okay, we have in order. We have freedom of religion, freedom of speech, freedom of the press, freedom to, assemble, right? And we have the right to petition the government on redress of grievances. Okay, so those are the 5 in order that the First Amendment protects, right? It puts limitations on government. So without further delay, let's dive into this First Amendment. So like I said, the very first civil liberty that's protected from government intrusion, from government that limits government's power, okay, is in fact religion. It's not speech, it's not the press, it's not our ability to assemble or our ability to tell the government off. No, it is in fact religion. So, within the freedom of religion, there are 2 clauses that we're going to be diving into. One's called the Establishment Clause. The other one's called the Exercise Clause, or the Free Exercise Clause. We're going to talk about both of them today. So let's get to this, right? So the provision of the Establishment Clause is the provision of the First Amendment that prohibits government from endorsing a state-sponsored religion. Okay. So it prevents, it prohibits, it hinders, it stops the government from creating a state-sponsored religion. And there are two ways we can interpret this, right? One way is the government cannot say, you aren't in charge today, so we're going to increase your taxes by 5%. Can't do that. It's also been interpreted as a way of preventing the government from favoring some religious beliefs over others, or religion over non-religion, right? So the Establishment Clause here can be, the interpretation of this can be that yes, we have the government is not allowed to create a religion, is not allowed to enforce a religion, to adopt a religion, but also to prevent a religion from being over another, right? So that's the Establishment Clause. You might be thinking, separation of church and state. Yeah, I've heard this before. Well, the separation of church and state does not exist in the U.S. Constitution, in a Declaration of, in the Declaration of Independence. Sorry, I was thinking of the Universal Declaration of Human Rights. But anyways, it's not found in the Bill of Rights, in the U.S. Constitution, or in the Declaration of Independence. This phrasing, separation of church and state, does not exist in any governing document. With the one exception of it was a letter. Yes, President Jefferson, Thomas Jefferson, he wrote a letter to the Danville Baptist Church, reassuring them against establishment of a national religion. He was reassuring this congregation that we were going to have this separation of church and state. He penned those words. This phrasing, separation of church and state, was written in a letter from the President of the United States to a Baptist church. Okay, so that's where we get this from. It's not from the Constitution. Although it's derived, this concept, separation of church and state, is derived from the Establishment Clause, right? But the phrasing does not exist. It didn't exist until Thomas Jefferson penned those exact words, if that makes sense. In God We Trust, this motto has appeared kind of randomly, intermittently, on U.S. coins since the 1860s, and yet it was not mandated on paper currency until 1957, which, by the way, it's not that long ago. I mean, it's within my parents' lifetime, right? The phrase "one nation under God" was not added to the pledge until 1954, right? So, brings us to an interesting question. What do you think about this? What do you think about the pledge being mandated in schools? Should schools mandate the pledge, which has this phrase, "one nation under God," in it? Now, I'm not here to give my thoughts on that. I'm not here to tell you one way or the other. But it's a question. All questions are not intended to be cynical or intended to be, right, anything like that. They are nothing more than prompt thinking, right? So you're going to see that throughout this lecture, as you've seen previously already. What do you think about this? So we see the involvement here with the Establishment Clause. Everson v. Board of Ewing Township, 1947. The Supreme Court ruled that the New Jersey's transportation plan was in fact constitutional because it had a secular legislative purpose, safe transportation for school children, and neither advanced or inhibited religion. So this case, I would recommend looking into it. Basically, in short, the school was a private school, a private religious school, and it was receiving tax dollars. And so, did this cross the line of separation of church and state? Well, as long as the action didn't advance religion, and as long as it didn't inhibit religion, it's constitutional, and it did serve a secular purpose, right? So this did not cross this threshold of separation of church and state, at least according to the Supreme Court in 1947. We fast forward to Engel v. Vettel. Forgive me, I'm absolutely horrible with names. This 1962 Supreme Court case ruled that reading a government-sponsored prayer in public schools is unconstitutional. Do you agree with this decision? I mean, is saying a prayer at a public school, is this crossing the line? Is this somehow advancing a religion, or is it inhibiting a religion? It's an interesting thought. It's an interesting question, right? And all of this comes down to our own ideology, our own beliefs, not only in terms of religion, but our political beliefs, right? But it's an interesting question, nevertheless, to have that discussion. Lemon v. Kurtzman, the 1971 case, a Supreme Court case, established what's known as the Lemon test to determine whether government aid has the effect of advancing religion. So to be constitutional, an action of government must meet all three requirements. This is also referred to as a three-pronged test. Okay, that first, the purpose of the government action must be not to advance religion. The effect of the action must not inhibit any religion, and the action must not lead to an admissible entanglement between church and state. In other words, as long as the government action, whether it's a piece of legislation or whether it's the action of a government employee, as long as it does not advance religion, as long as it does not inhibit any religion, and as long as it does not entangle church and state, it's constitutional according to the Lemon test. Right? So now we move on into the Free Exercise Clause. The Free Exercise Clause is the provision of the First Amendment that limits government to prevent individuals from practicing a religion. Right? So we have the freedom of religion, right? Not the freedom from religion, as some may argue. Right? The idea here is, yes, the government cannot mandate or endorse a religion, any religion. But at the same time, we have the freedom, you and I do, to practice any religion we want. Whether that's Christianity, Judaism, Islam, or you know what? Nothing at all. Right? Of course, we have Hindu and Buddhist, and I'm not excluding them at all. But the point I'm trying to make here is we have the freedom to choose of the religions of this world what you and I will practice or not practice. Right? It's really an interesting question when we start thinking about this, right? This is often a topic that comes up, right, when we talk about the First Amendment in the context of religion. So the idea here is, since I did not witness the Big Bang, how do I know it happened? Well, I learned about it through a textbook, or I learned it from a teacher. Did I witness God speaking the universe into existence? No. How did I learn about that? I read it from a book, or I learned it from a preacher. Because we did not witness these two events. I did not witness the Big Bang, neither did you. I did not witness God speaking the universe into existence, neither did you. By faith, because we did not witness it, we did not see these things, we've accepted one of them as truth, right? Because we honestly did not witness it. We just accept one of these by faith. So one could argue, right, that everything, whether you're religious or not, it's a religion, right? Because ultimately, in the end, because we have not witnessed these things, we have not seen them with our own eyes, then it's an interesting conversation to have regarding the freedom exercise clause here. It's an interesting thought. Moving on with this concept of free exercise, right? Wisconsin v. Yoder, 1972. The Supreme Court sided with the Amish parents who refused to comply with Wisconsin's universal compulsory school attendance law. You may be thinking to yourself, what is this? What is compulsory school attendance? Well, in 1972, Wisconsin had it where students was forced. They were mandated to be in school. There was a violation of the law if students were not attending school. Okay, that's what we mean by compulsory school attendance. The court did rule, though, in favor of the parents. They argued that their religious beliefs outweighed the interests of the state in terms of education. So we see that the government cannot inhibit nor advance religion, and we also see the Supreme Court upholding our ability to practice the religion, if any religion, that we want to. The Employment Division v. Smith 1990 case, the Supreme Court sided with the state of Oregon, ruling that states can enact laws that have an incidental impact on religious freedom so long as they have served a valid state purpose and are not aimed at inhibiting any particular religion. So we're starting to see this progression, right? This growth isn't the word I want to use, but this progression, we'll use that one. That one's the best. This progression of thought on separation of inhibiting, advancing, and free exercise, right? We're starting to see this progression. And in 1990, they said that where states can intrude on it as long as it serves a valid state purpose. In other words, we can't just enact something just because we want to do it. It has to be a legitimate state purpose, and that has to be clear, right? So it's an interesting. Do you think though this is an attack? That this court decision was an attack on religion, or continuing, so is it an attack in the context of it's intruding more on the states, on government being more involved in religion, or do you think that this was an attempt to make it clear that separation? What's your take? It's interesting. Now we move into the second protected civil liberty under the U.S. Constitution, under the Bill of Rights, under the First Amendment here. Real quick, let's get to Schneck. Schneck v. United States, 1919. During World War I, Charles Schneck passed out leaflets declaring the draft. During World War I, the U.S. government did enforce or did employ the draft. So men 18 and above, they were recruited. They had to serve in the U.S. military to fight. And Charles Schneck here passed out leaflets calling the draft, a violation of the 13th Amendment, which prohibited against involuntary servitude. So he was arguing that the draft was a violation of the 13th Amendment. That's what he was arguing, because the 13th Amendment protects us from being protects us from involuntary servitude. So It's interesting. The Supreme Court established what's known as the clear and present danger test. Remember when I asked you earlier, in the first slide, about do you have free speech? Do you have absolute free speech? Well, the answer is yes. Right? Going back to that story I told you about my brother, there was no government chip in his head that prevented him from saying that. There is no chip in my head or in your head that prevents you and I from saying what we want when we want. Even if we want to yell fire in a crowded theater, there is nothing preventing me from having that ability. I can say that, I can do that if I want to. But there are consequences. But there are consequences for yelling fire in a crowded theater. While I have the ability to do that. This is true. I do have absolute free speech. Just note that there are certain speech that crosses the line. That there are consequences for certain speech. Right? And that's what was happening here. The Supreme Court established this clear and present danger test. I can't yell fire in a crowded theater, and ruled that the defendant, that is Charles Schneck, his conviction under the Espionage Act of 1917 was in fact constitutional. So yes, he was engaging in political speech. Yes, he was engaging in free speech. Absolutely. But the draft was required for the government to survive. Right? The idea here is that we were at war. And if we hadn't lost, the government would fail. Right? And so limiting, by interrupting and hindering our ability to draft people into the military, that crossed the line. That prevented the government from functioning. So the Supreme Court ruled against Charles Schneck here. Neal v. Minnesota, 1931, the Supreme Court invalidated a Minnesota state law that prohibited prior restraint against materials that were defamatory or obscene. So, what is prior restraint? Well, I'm glad you asked. Prior restraint is government action that prohibits speech or other expression before the speech happens. Right? So, in other words, we're going to prevent that from even happening before it even happens. Right? That was prior restraint, and so they struck it down. And how do you define obscenity? I mean, this is a conversation that is very, very interesting. How do you define what is obscene? I don't know if I can. I just know it when I see it. Right? That's a famous quote from a justice on the Supreme Court. I cannot remember who said it off the top of my head. I'm absolutely horrible with names, but I know obscenity when I see it. It's just really hard for me to define that. And it might be the same for you. Right? What I may find obscene, you may not, which is interesting. Right? One of the topics within this context is, should musicians and artists, should they use profanity, right? Obscene language, right? The F word, for example. Should artists and musicians be allowed to use said language? Some may say no. Some may say no. It's a violation of morality. Some may say no because it's just it's obscene. Right? Others may say, well, it's the artist's interpretation. It's the artist's feeling. It's their content. So as long as it is an artist, as long as it is art, as long as it's music, I see no problem with this, right? Again, it comes down to ideology. But it's an interesting thing. What do you define as being obscene? Right? Yeah. Ever notice that radio stations will bleep out certain words in certain songs? um, that's because the government has deemed the radio stations, and we're going to dive into this deep when we get to the media, but the radio stations are regulated by the FCC, the Federal Communications Commission. I had to think about that one for a second. The FCC. And the FCC has guidelines and standards about what is obscene. So those words are bleeped out over the radio because the FCC regulates um, the radio waves and regulates media. Not media, but a little bit of media. But you know what I'm saying, radio stations. Anyways, so what do you find to be obscene? In terms of music, I will make this one quick comment. Well, one song that I find to be obscene, and I don't know if there's any profanity in it. I can't remember, and I can't remember the artist. But the song title is "Blurred Lines." And I just have a quick story, just real fast about that. Very long story short. I used to work as a staff member of a university, and they had a recruiting event. And at the recruiting event, this recruiting event was to the public, parents, along with mostly middle school and high school students visited, mostly. And during lunch, which my office provided for the entire event, during the event, which this was held outside for parents and for families to visit the college, they played, the DJ played Blurred Lines. Now, I would encourage you to actually don't listen to the song, go read the lyrics. Right? Long story short, I thought that was inappropriate. I don't care about the song, right? What you do, what I do, right? I don't care about. But in the context of putting forth a image, putting forth and using the time of these parents, I didn't know if that was the most appropriate song to use, right? I view that as being obscene, at least for that particular event, if that makes sense, right? So I reached out to those who are above me and let them know that, hey, maybe this isn't the best thing to do, right? For future. DJs are fine, absolutely. Music is great, but to have that particular song, you see where I'm going with this? I'm digressing, but what I'm trying to get at is we should pay attention to not only what our elected officials believe to be obscene, but how our justices view what is obscene. Because you may think that story I just told you is that I'm making something out of nothing, that song isn't as bad as I'm making it out to be, and it was perfectly fine for that DJ. Those who may think otherwise, right? Regardless of where we stand, the point I'm trying to make here is we obviously have some differing opinions. And those differing opinions, if you and I have that, then absolutely our elected officials, especially here in Texas, since our judges are elected by you and I, they may have different opinions on what is obscene. They may find to be obscene as something you don't, or vice versa. So we need to pay attention to that. That's the whole point to that story. But I'm digressing. Let's move on. Tinker v. Des Moines School District, 1969, the Supreme Court ruled that students had the right to wear armbands protesting the Vietnam War. Right? So the idea here is that even in times of crisis, even in times of war, that we still have the right to free speech. Now, the difference here between Schneck and Tinker here, or should I say the school district here, the difference here that we need to make is that Schneck was literally stopping government from carrying out one of its enumerated powers, maintaining and building an army and a navy. So hindering that, he is literally encroaching on government's basic function. Okay. Here, students protesting the Vietnam War is completely different because you're protesting a policy choice. You're protesting a governmental decision, right? You're not protesting the government's function. You're protesting against a policy outcome, right? These are. It may sound like we're just talking semantics, but in reality, it's not, right? And so I just want to make sure that was clear. Cohen v. California, 1971, the Supreme Court ruled that government cannot forbid shocking language that is not legally obscene and does not provoke violence. So, bumper stickers that say F, insert whatever presidential name here, bumper stickers that say, F you, things like that. It's loud. Not only just bumper stickers, but t-shirts, right? This stuff, while it may be shocking, it's not legally, it's not forbidden, is what I'm getting at. Supreme Court case here established that. Miller v. California, 1973, the Supreme Court revised the standards to define contemporary community standards as local community. What we're talking about here is in this Miller v. California case, they established criteria that must be met, right? The material must depict or describe sexual conduct in a apparent offensive way, right? That it must be such that this content, this sexual content or conduct, is such that the average person, not a justice, not someone who reviews and questions law, but just the average person, right, can apply these standards and will find that work taken as a whole appears to be prudent, appeals to the prudent interest, meaning that it does cross that line, that this is actual obscenity, right? So what this case does for us is it basically establishes this thought, this doctrine, that the closer something is to art or scientific value, political value, the closer you are to some sense of value, okay, the more protected your speech will have, right? Or the more protected something that you may find to be obscene has, right? Prime example to use here is pornography and the porn industry, right? That these individuals who work in that industry are performers. They're adult models or adult performers, however you want to view that. That's leaning into art, right? That's the legal argument here. Now, which brings up a really good question, though. What should we do with pornography, if anything? Should we try to regulate it? Because some would, I would go as far to say that some, if not the majority of people, would say it is obscene, right? Should we regulate it? Ban it? Should we? It's an interesting question to have to ponder, especially in the context of abortion, right? Because we're going to talk about Roe v. Wade in just a moment. But what's interesting to note is that Roe v. Wade establishes privacy, and the idea that striking Roe v. Wade down may actually open up a Pandora's box to questions that I don't know if we want to answer. We'll get to that in just a moment. But I just want to put this out here and want to make sure we understand that the closer you are to art, the closer that an object or a piece of clothing or a particular speech has to art or has some kind of value to it, the more protected that speech or that item is. That's what I'm getting at. New York Times v. Sullivan, continuing on with the First Amendment here, but now we're moving on into the press. Right? We're moving into the press section. So the Supreme Court ruled in New York Times v. Sullivan that public officials could not recover, let me say it again, could not recover damages for defamatory remarks unless they could prove that that person or persons making the statements knew that they were false or made them with reckless disregard of the truth. So what we're getting at here is the press's ability to criticize government. Right? I want to take a moment here. We're going to dive into the press in another chapter video, but I want to take this moment to really understand something here. The press. The press is protected by the First Amendment. We have the right to a free press. Absolutely. Because the press is designed to the media. When I say the press, I'm referring to the news media. Okay? The press is designed, the news media is designed to let you and I know what's going on. Lets you and I know what's happening in government. If press does not have freedom, if the press is not free, then what we get is basically propaganda from the state, which is what we see in Russia. In authoritarian regimes, that's what we get. News that is packed, propaganda that is packed as news. So a free media, a free press is absolutely essential for democracy, no matter where we stand, no matter where you get your news from. Fox News, MSNBC, CNN, put that to a side. We must have a free press so that it can criticize government. Press, the media, is not designed to praise any elected official, Democrat or Republican. They are not designed to prop up anyone other than the people. The news media is designed and it allows to be operated by the Constitution, by the Bill of Rights, by the First Amendment, so that it can openly, freely give us information. If it criticizes the president or if it criticizes a member of Congress, so be it. If it tells us, if it informs us of what is happening and we find that good, so be it. The point is, they must be free to operate, free to be able to investigate, to interview, to question, to prod, to provide you and I information. Right? That's what I'm getting at. But anyways, I'm digressing a little bit. What we should note here is that only states have libel laws. These are laws that if I write something and I publish it and I know it's defamatory and I know it can hurt someone's reputation and I know it's false, well then I can be sued at the state level in civil court for this violation, right? For libel. But there are no federal libel laws. There aren't. They do not exist. This is given to the states to handle. So I just want to put that out there. Shall we move on? Let's move on. Johnson v. Texas, 1989. The Supreme Court ruled that burning the U.S. flag is constitutional. Do you agree? Right, this idea that I can burn the American flag in protest. I am mad. I am mad as all can be. and I'm going to protest, and the only way I know how is grabbing this flag and burning it. Do you agree with that? Do you agree with this decision? It's interesting. Well, it's interesting. Because we're taking it out of the context, and we're putting this in now in context of politics, right? Is it okay for anyone to burn the American flag? There are differing views on this, right? Differing views. And what's interesting, when we start talking about political speech and political protesting, I'm reminded, and I'll make this brief. I'm reminded of Kaepernick, right? The football player Kaepernick, who took the knee during the national anthem. Right? He received a lot of criticism for that. And I am loaded with questions. I just have questions for my questions. And I wonder how many of us actually stand up at our homes when we watch a football game. Do we stand up for the pledge? Or, I'm sorry, during the national anthem, do we do that? Or do we get up, go to the refrigerator, get our favorite snack, our beverage, get back on the couch during the national anthem? Right? Did Kaepernick really violate something here? Right? I'm digressing a little bit. What I'm trying to really get at, no matter how we view this, no matter where we stand with Kaepernick or with burning the American flag as political protest, no matter how we view that, political speech is extremely important and needs to be protected. This is more of principle rather than a stance on a certain issue, right? Political speech, the Supreme Court has ruled in favor of political speech time and time and time again. This is one picture of that. This is one case of that. So, do you agree, though? Do you agree? It's an interesting proposition. Virginia v. Black, 2003, the Supreme Court ruled that Virginia's state statute, that statute is a piece of legislation, it's a law that Virginia passed, right? That a statute making burning a cross on display a felony was in fact unconstitutional by its assumption that committing this act had the intent to intimidate an individual or group. Now, you and I know, through our history, we know that the KKK used this as a form of intimidation. Right? The burning of a cross has been used to intimidate people historically. Okay? To prevent people from voting, to prevent people from participating, from living. Okay? Specifically, the KKK aimed at minorities and blacks. Okay? Is this the right call? Is this the right decision? I don't know. The argument really, I guess if we were to try to look at from the Supreme Court's point of view, the assumption itself is the bad part. It's not the actual, they're not really thinking about the burning of the cross as an act necessarily. They're looking at the assumption that we make about that. But historically speaking, on the other hand, we know what that's used for. I have questions. Snyder v. Phelps, 2010, the Supreme Court ruled that individuals are immune from civil liability for protesting at a funeral, even if those who are protesting make comments that inflict emotional distress on attendees. What do we say about this? There is a group that's known as the Westboro Baptist Church. They are more of a hate group than they are a church, because they are known for two things. They are known for extremely defamatory, insulting banners and flags and slogans aimed at other religious groups and other groups within society. And they have the other thing they're known for is protesting at fallen soldiers' funerals, saying that those who served our nation and who fell and died are going to go to hell. They are very, very blunt, and they are very rude and defamatory with the language that they use. The Supreme Court said that these people cannot be held civil liable for that. So they're protecting, while we may not like this speech, and let's face it, there is some speech I don't like, there's some speech you don't like. But in the end, free speech is granted to all, not to those that we necessarily agree with, and it is granted to those that we disagree with. Point I'm trying to make here is that's the Supreme Court's thought, right? Is upholding political speech. So we move away now from the First Amendment, now to the Second Amendment, right? And we're probably very familiar with the Second Amendment here, right? Let's read this verbatim. This is exactly how the Second Amendment is written in the U.S. Bill of Rights. A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. A couple of thoughts on this, right? One argument that some will make is that the right to keep and bear arms is reserved for the militia, right? This is all coming down to semantics on how English is written. But notice that we start off with a well-regulated militia. But if we take out the middle part here, this will read, a well-regulated militia, the right of the people to keep and bear arms shall not be infringed. The idea here that some would make is that the Second Amendment, is, some would argue that it is intended for the militia to be armed. I don't know if that's the correct way to interpret this, right? Most often we interpret this as the latter here, that we kind of ignore the first part and we just go straight to the people to keep and bear arms shall not be infringed, right? So let me ask you a direct question here. What does this mean? Like, let's dive into this. Bear arms. What does this mean? Seriously. How do you define an arm? And if you're thinking of that meme with an individual with two bare arms, hairy and bare arms, well done. Right? But what is an arm? How do you define that? Is it a sidearm? Is it a firearm? Is it an assault rifle? Is it a shotgun? Is it a sawed-off shotgun? Is it a howitzer? Is it a tomahawk missile? Is it a Gatling gun? Is it a hand grenade? Flamethrower? What is an arm? Because the Constitution here is kind of vague, right? It says the right to keep and bear arms. What does this mean? So I'm going to go to an extreme to get to a point, okay? Bear with me. Do I have the right to own a weapon? Well, according to the Second Amendment, yes. Do I have the right to a nuclear weapon? And yes, you heard me right, nuclear. Do I have the right to a chemical weapon? A biological weapon? Do I have this right? Constitution, according to the Second Amendment, says I have the right to keep and bear arms. What does that mean, though? Do I have the right? Am I entitled to a nuclear weapon? I think most of us would say no. But I do not own that right to have that. Excuse me. So, what does this mean? What does this look like? In short, we have accepted certain limitations, right? We've accepted certain limitations already. Because obviously there are some arms that you and I both say we do not agree with, that I am not entitled to. So ultimately, the question becomes, when we talk about the Second Amendment, what limitations are we willing to accept? And this is going to vary, right? According to our ideology, how we view the world, our personal beliefs, everything like that. This all comes together here on answering this question. What limitations do we accept? Right? It's an interesting conversation to have. DC versus Heller, 2008 case, the Supreme Court ruled that individuals have the right to possess a firearm within the home for safety and not be required by law to have it unloaded, bound by a locking device, or stowed away. But this decision was confirmed a second time with McDonald v. City of Chicago, 2010, by applying it to state law. Moving on forward with the Fourth Amendment, protections against searches and seizures, the right of the people to be secure in the person's houses, papers, effects, against unreasonable searches and seizures shall not be violated, and no warrants shall be issued but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. In other words, this is the due process. We have the right to be secured in our persons, in our effects, in our things, in our homes. That cannot be violated without a warrant and without probable cause. The police cannot barge in without probable cause. And that's what we're getting at here. The Fourth Amendment makes this clear. All right. Mapp v. Ohio, 1961, the Supreme Court established the exclusionary rule. The exclusionary rule, by the way, is a requirement that evidence obtained as a result of an illegal search and seizure cannot be used to try someone for a crime. In other words, if evidence was obtained in an illegal attempt, if due process rights were not upheld, the evidence is kicked out. U.S. v. Leon, 1984, the Supreme Court established the good faith exclusion. I can't speak now all of a sudden. Forgive me. The good faith exception rule, which means the meaning evidence won't necessarily be excluded if law enforcement followed proper procedures for obtaining it. So, as long as due process rights were observed and were respected, then any evidence that is collected may be used against us, or may be used against you, or may be used against a citizen, right? So as long as due process rights are respected, law enforcement can investigate. Carpenter v. United States, 2018, the Supreme Court ruled that obtaining phone records without a warrant is in fact unconstitutional. Despite the Patriot Act being used in the manner for which it did, the Supreme Court came out and said that this is a violation of the Constitution. I know I'm moving a little fast, but we have a lot to get through, so I want to make sure we have time to do that. Right? So, self-incrimination, the Fifth Amendment. Now, I don't know about you, but as a kid, I pleaded the Fifth frequently. Right? Pleading the Fifth is invoking your Fifth Amendment right not to incriminate yourself. Right? An action or statement that admits guilt or responsibility for a crime. You have the right to not speak. You and I have the right to speak and to speak our minds, to tell the government what we're thinking, and to list our grievances, and to have political speech, and to be able to say what we want, absolutely. We also have the right to keep quiet, and that's what the Fifth Amendment does. Right? Double jeopardy is a prosecution pursued twice at the same level of government for the same criminal action is forbidden. The Fifth Amendment protects us from double jeopardy, that we cannot be prosecuted twice at the same level of government for the same criminal action. So the Fifth Amendment gives us that. Miranda v. Arizona, 1966, the Supreme Court ruled that authorities must observe adequate procedural safeguards before questioning accused persons. So, this is where we get Miranda warning from. Miranda rights, it's often referred to as well. And if you watch Law and Order any at all, you're pretty familiar with this, right? The Miranda warning is as follows, and I quote, "You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be provided for you. Do you understand the rights I have just read to you? With these in mind, do you wish to speak to me?" That is known as the Miranda warning or the Miranda rights. In other words, the police, law enforcement must tell you, must inform you of your rights. And that's what this does. The Miranda warning, the Miranda rights tells you you have the Fifth Amendment right to remain silent, right? So the Miranda v. Arizona, that's where we get this from. That's where we get the Miranda warning from. Eminent domain. This is the power of the government, this is found in the Fifth Amendment, to take or use property for public purpose after compensating its owner. It's also known as the takings clause of the Fifth Amendment. So the takings clause or eminent domain is basically government can seize land. Government can seize land but they must give compensation to the owner. So the government can't just take away anyone's land without proper compensation for that land, right? Kello v. City of New London, Connecticut, 2005, the Supreme Court ruled that eminent domain could in fact be used for economic development as well with serving some kind of public good, public service. Foreman v. Georgia, 1972, the Supreme Court declared that the death penalty as then applied was unconstitutional because it allowed too much discretion. State legislatures responded to the ruling by adopting new capital punishment laws and procedures and methods of execution. Foreman v. Georgia, the Supreme Court ruled that the death penalty applied to murder and rape cases were in fact a cruel and unusual punishment using the electric chair. So the states responded by adopting new procedures and new ways of carrying out capital punishment. Atkins v. Virginia, 2002, the Supreme Court ruled that a person found to be mentally disabled cannot be executed. So we see the Eighth Amendment here being applied as well. Being applied in this way is what I'm trying to say. So lastly, we're almost done here. Right, so Griswold v. Connecticut, 1965, the Supreme Court established a right of marital privacy in the Constitution when it invalidated, in other words, struck down, a Connecticut state law prohibiting the use, in other words, preventing the use of contraceptives. Now, fast forward to 1973, Roe v. Wade, the Supreme Court ruled in this famous landmark case that states cannot restrict abortion the first 3 months of pregnancy as the Constitution created a right to privacy. Now, this conversation, right, we typically have very strong views about abortion. No matter where we stand about this, right, the practice of it, what it's actually doing, right, regardless of how we view that, this is extremely controversial, and I know you already know that. So I'm not telling you anything new. It's extremely controversial, And this is a difficult, complex subject because it invokes everything from our understanding of life, our beliefs, our potential religious beliefs, our ideology, our upbringing, our experiences with life. Everything merges in this topic. So no matter where we stand, okay, this is not an easy topic whatsoever. But the practice itself, right? Whether we're pro-life or pro-choice, hopefully we'll get to a point where the practice itself is not practiced much, right? Regardless of where we stand on this issue, no matter if we're Republican, Democrat, Liberal, Conservative, no matter where we stand, the practice itself. But what's interesting to me about this conversation is that what would happen? How would the debate change if instead we were talking about regulating women? What if we talked about regulating men? And what do you think? Would that change this discussion? Well, because we're talking about Roe v. Wade created a right to privacy. Okay, if we understand basic biology, that means that, and I'm trying not to be crude here, right? But the idea of we are entitled to right of privacy. What about those who are masturbating? And what I'm trying to get at is if the discussion was about men and regulating men, Roe v. Wade becomes important because it establishes this sense of privacy. Now, or does it? Well, this is one of the arguments that's out there. But what I find interesting is I wonder, and maybe you agree with me, and maybe you don't. I'm actually interested. What do you think? Do you think that this discussion would be completely different if we were talking about regulating men rather than women? This is interesting, and after all, this invokes everything, y'all. This invokes all our ideology, our beliefs, our experiences. It invokes everything. So this is not easy. This is complicated. This is controversial, and usually we have strong opinions about this topic, and I get that, and I understand that. But do you think it would be different? Do you think that this discussion would be different if we were talking about regulating men? But one last thought, and then we'll end it after this. The thought that the idea that, let's hypothetically say that we have a man and a woman, and they agreed to have a family, right? Well, if you think it through, right, that woman they're pregnant for 9 months, right? That man can go impregnate hundreds more women if he wanted to, if they agreed to that, right? The point I'm trying to make here is that there is a legitimate discussion that is it women that we should be regulating, or is it men that we should be regulating? Or should we regulate at all? I don't know. So we are going to wrap this up with this thought that this is complex, and that if there's anything that I've said so far, if you have any questions about the content, if you have any questions for me whatsoever, please feel free to reach out to me. With that being said, we'll conclude this video, and we'll see you next time. Peace.